Imagine taking like a really messy, highly politicized, completely secret trial.
Right, a trial of a Chinese physicist?
Exactly. A trial that ended in a 20-month prison sentence.
Hmm.
And then taking that entire official court transcript, all the legal documents, and just feeding them into 6 different cutting-edge AI models.
Just to see if the legal math actually adds up.
Yeah. I mean, welcome to today's deep dive into the source material. Whether you're, prepping for a meeting or you're just insanely curious about the intersection of artificial intelligence, law, and human rights, this deep dive is custom tailored for you.
It really is the ultimate stress test for human justice. I mean, you are taking a system built on complex power dynamics and subjecting it to a completely impartial digital auditor.
Right, because an AI doesn't care about the political weather.
No, not at all. It just processes language and logic. It runs pattern recognition on a massive, unforgiving scale, just looking for structural integrity.
And that is exactly what we are doing today. So the stack of sources we're looking at comes from this fascinating project called Chat2Elms.
Yeah, the researchers for this project gathered official Chinese legal documents. So specifically, we're talking about an indictment, a trial judgment, a second instance ruling, and this really remarkable document written by the defendant himself called a prison blood letter.
Such an intense title. So they took all of this raw legal text and fed it into, Copilot, DeepSeek, Gemini, Grok, Qwen, and ChatGPT.
All 6 of them.
Right. And the mission of this deep dive is to explore exactly what happens when you use top-tier AI models as an impartial digital jury, basically, to audit a highly controversial, politically charged legal case.
Which is a huge undertaking.
It really is.
Right.
And actually, before we unpack the findings, I need to make one thing absolutely clear to you, the listener. Because these sources deal with politically charged content involving the Chinese judicial system and the Chinese Communist Party, we want to make it absolutely clear that we are not taking any sides.
Right. We are remaining completely objective here.
Exactly. We are impartially reporting on the content provided by these 6 AI models. And we are not endorsing the political viewpoints within them. We are simply conveying the fascinating ideas contained in the original source material.
Perfectly said. I mean, we're looking strictly at the logic, the law, and how the AI analyzed both of those things.
Okay, so let's set the stage. The human element at the center of all these documents is Dr. Chen Jingwan. He's a physics PhD, an independent scholar living in Kunming.
Right.
And in September 2022, police raid his home without a warrant.
No warrant at all.
No warrant. And he is ultimately sentenced to 20 months in prison for a crime called picking quarrels and provoking trouble.
And that specific charge is crucial context here, because in the Chinese legal system, that charge is widely known as a pocket crime.
A pocket crime.
Yeah, historically, it was designed for actual physical disruptions, things like street brawls, smashing shop windows, inciting riots.
Physical stuff.
Right. But because the legal definition is so structurally vague, authorities have essentially turned it into a giant pocket. They can just stuff any behavior they want to penalize in there.
Especially in the digital realm.
Exactly.
Okay, let's unpack this. Because if you're going to be charged with inciting a digital riot, you'd expect, I don't know, a massive coordinated operation, right?
You would think so.
But Dr. Chen's crime, his actual crime, was using a VPN to retweet and like posts on Twitter, which is now X.
Yep. Just likes and retweets.
And the content of these posts, let's see, it was an Umbrella Girl cartoon, photos of candlelight vigils, academic essays on complex systems, and even official public statements from the U.S. Embassy.
Which is publicly available information.
Right. And he had fewer than 100 followers. His total retweets over several years were less than 100. That's like arresting someone for starting a riot because they whispered a complaint to 3 people in an empty parking lot. How on earth did the prosecution argue this caused serious public disorder?
What's fascinating here is how the AI models unanimously agreed that the conviction lacked any factual basis.
They all agreed.
All 6 of them, independently. They parsed the legal jargon and pointed out that in any functional legal system, if you claim someone yelled fire and caused a panic, you have to prove the panic actually happened.
Right. Where is the stampede?
Exactly. But the models noted that the court provided 0 data. No metrics on virality, no evidence of offline protests, and absolutely no proof of actual societal disruption.
0 data. Literally nothing.
None. Quen, for instance, did this deep semantic analysis of the trial judgment. It noted a complete absence of quantifiable metrics.
Wow.
Yeah, standard legal proof for a digital disruption requires showing virality rates or network outages, economic damage, something. ChatGPT pointed out that the court essentially just swapped out objective evidence for a subjective label. They just called it serious disorder and called it a day.
So the LLMs are essentially looking at the math of the networks. They're reading the judgment and saying, show us the data logs.
That's exactly it. Grok took it a step further and analyzed the mechanics of information cascade. It highlighted that an account with under 100 followers, engaging in low-frequency retweeting over multiple years, physically lacks the algorithmic bandwidth to trigger a societal disruption.
It's just mathematically impossible.
Right. The court was asking the public to believe that a whisper in an empty room caused an avalanche.
So if the evidence of a physical disruption was mathematically impossible, you really have to wonder how the prosecution justified the charge on paper. Like, they couldn't just say he broke the internet if the internet was provably fine.
Right, which leads us to how they targeted the posts themselves. They didn't just claim disruption. They officially labeled the content of Dr. Chen's retweets as fabrications and fake news.
And this is where the AI stepped in again.
Oh, absolutely. This is where models like DeepSeek and Copilot really tore the court's logic apart. They identified a massive category error.
A category error. How so?
Well, in legal terminology, for something to be classified as a fabrication or fake news, it must be a falsifiable fact.
Meaning you can prove it wrong.
Yes. It has to be a statement that can be proven objectively true or false through empirical evidence.
Right, like claiming the unemployment rate is 0 when it's actually 10%. You can just check that against the ledger.
Yeah.
But Dr. Chin was sharing cartoons and embassy statements. How do you legally define an umbrella girl drawing as fake news?
You don't. And that was the AI's core finding. DeepSeek pointed out the profound legal absurdity here. An artist's metaphor is not a fact.
Right.
Political commentary is an opinion. A diplomatic press release from an embassy is a matter of state record, not a fabrication by a random user.
It's literally just a document.
Exactly. None of these are falsifiable facts. You cannot legally or objectively prove that a cartoon is false. The AI models showed that the court deliberately conflated subjective viewpoints with objective falsehoods to just manufacture a criminal charge out of thin air.
Okay, but let's assume for a second, just to play devil's advocate, that the court could somehow prove a post was objectively false. To secure a criminal conviction, don't they still have to prove he knew he was spreading a lie?
Yes, the principle of subjective intent. It's a cornerstone of criminal law. The prosecution had to prove Dr. Chen knew the information was false and shared it anyway with malicious intent.
And since they couldn't even prove the posts were fake, how on earth did they prove his internal state of mind? Did they have chat logs? A confession?
They had none of that. And Gemini's insight on this aspect is absolutely chilling. Gemini did a deep dive into the specific logic the court used to establish intent.
What did they find?
The court ruled that because Dr. Chen is a highly educated physics PhD, he, and I quote, should have known right from wrong.
Wait, so they weaponized his education?
They did.
That is a total logical fallacy. That's like saying a mechanic must have intentionally sabotaged your car simply because they know how engines work. It replaces the need for actual evidence with a completely biased assumption about his identity.
It is the textbook definition of the presumption of guilt. Gemini highlighted that using a defendant's intellect as a substitute for hard evidence completely violates the core principles of justice.
It's mind-boggling.
If we connect this to the bigger picture, a researcher's default mindset is skepticism, right? It's observation, it's questioning, it's not blind malice.
Right, that's what a PhD trains you to do.
Exactly. By criminalizing his intellect, the court wasn't just punishing his physical actions on a keyboard, they were legally punishing his capacity to think.
That is heavy. So if the evidence of disruption was mathematically impossible, and the content itself wasn't legally fake, and the proof of intent was just a weaponized PhD, how did they actually secure conviction?
Well, this leads us directly to the procedural collapse of the trial itself. The AI models, particularly ChatGPT and Qwen, conducted a systemic analysis of the trial proceedings, and the picture they paint is a procedural nightmare.
Let's hear it.
First, the trial was held entirely in secret. It was a closed-door trial. Despite there being absolutely no legal justification for it, there were no state secrets.
Just a guy sharing academic papers and cartoons.
Right. Second, the burden of proof was completely inverted. In a standard justice system, the state must prove you are guilty. Here, the court essentially told Dr. Chen to prove he didn't harbor malicious intent.
Guilty until proven innocent.
Exactly. And third, when he eventually appealed the decision, the appellate court didn't even bother holding a hearing. They just rubber-stamped the lower court's ruling.
Wow. But here's where it gets really interesting, because Dr. Chen didn't just sit there and take this. While he was incarcerated, he wrote a defense. This is the document referred to in the project as the prison blood letter.
It's an incredible document.
It is. And he didn't rely on standard legal precedents or emotional pleas. He used his actual expertise. He built his defense on the CAP theorem.
Yes, which is a foundational concept from computer science and complex network systems.
Okay, you have to explain this to me. A physics PhD using the CAP theorem from a prison cell to fight a legal battle.
Great.
What is the CAP theorem and how does that even work in a courtroom?
Well, in computer science, the CAP theorem deals with how distributed networks handle data. It stands for consistency, availability, and partition tolerance.
Okay.
Essentially, it proves that in a massive distributed network like a global social media platform, you cannot guarantee that every single node will have the exact same consistent information at the exact same time without the system breaking down.
So Twitter is a distributed network. Millions of users are nodes.
Exactly. Dr. Chen mathematically argued that his tiny, isolated node, an account with fewer than 100 followers, physically lacked the bandwidth to force a system-wide consistency failure.
Right, he's just one tiny drop in the ocean.
He demonstrated that his low-frequency retweets could not override the network's partition tolerance to cause the massive societal disruption the court claimed. His intent was academic curation, not destroying the network.
He brought hard, verifiable network math into a courtroom built on vague legal fictions. He brought actual science to a kangaroo court. How did the judge handle a defendant mathematically disproving the charges?
By completely abandoning the law. The court records show that the judge literally yelled at Dr. Chen to shut up during the trial, repeatedly interrupting his defense.
So they just shouted down the math.
They did. And the AI models noted that this behavior isn't just a breach of courtroom decorum. When a judge screams at a defendant who is presenting a logical scientific defense, it actively denies the defendant's right to defend themselves.
It stops being a trial at that point.
Right. The courtroom ceases to be a place of objective law and becomes an instrument of sheer force.
That transition from law to force perfectly illustrates the broader implications here.
Yeah.
Because when you see a system systematically dismantle a person's logic with sheer volume, you have to wonder how this stacks up against universal international standards.
To answer that, the Chat2Kim's project used models like Grok and Copilot to map Dr. Chen's treatment directly against the 1948 Universal Declaration of Human Rights, the UDHR.
The gold standard for human rights.
Yes. And they didn't just find isolated errors, they mapped a step-by-step narrative of how the system stripped away his humanity.
It really sounds like a systematic dismantling. Where did the AI say it started?
It started by silencing his voice. Article 19 of the UDHR explicitly protects the right to seek, receive, and impart ideas through any media.
Which is exactly what retweeting is.
Right. Punishing Dr. Chen for simply curating ideas is a direct violation. But more insidiously, Copilot pointed out this creates a societal chilling effect. It sends a message that even the passive observation of unapproved ideas is a criminal act.
So first they attack the voice. Then what?
Then they attack his legal standing. Articles 10 and 11 guarantee a fair trial and the presumption of innocence.
And we know those were completely subverted.
Entirely. The system inverted his guilt, used his education as proof of malice, and locked him in a secret trial where the burden of proof fell entirely on him.
And then there's a judge screaming at him to shut up.
Yeah.
That has to violate something fundamental, right?
Yeah. It violates Article 1, the foundation of the Declaration, which states that all human beings are born free and equal in dignity. The AI models highlighted that subjecting Dr. Chen to 24-hour interrogations, which he detailed in his prison blood letter, and a judge screaming at him in open court is a direct assault on human dignity.
It's not about the law at all. It's just about breaking him down.
It's a calculated attempt to break the person mentally rather than adjudicate the facts.
And finally, they criminalize his intellect. Because using the CAP theorem to defend himself didn't just make the judge angry. It touched on Article 27, didn't it?
Exactly. Article 27 protects academic freedom and the right to share in scientific advancement. The models argued that when the court criminalized his use of network theory to explain his digital footprint, they were launching a direct attack on the scientific method itself.
They were punishing a scientist for thinking like a scientist.
That's exactly who the AI saw it.
You might be listening to this and thinking, okay, this is a terrible miscarriage of justice, but it's just one local trial incoming. So what does this all mean? Why should the listener care about this specific case?
If we connect this to the bigger picture, the consensus among these 6 AI models is that Dr. Chen's case is not an anomaly. It demonstrates the profound danger of vague pocket crimes.
Right.
When a legal system abandons objective evidence, when it substitutes a person's education for malicious intent, when it punishes a cartoon as fake news, and when it silences a mathematical defense with a shout, it exposes how fragile the line is between the rule of law and the rule of power.
Because law requires logic.
Exactly. Law requires logic, falsifiability, and evidence. Power only requires compliance.
Wow. Law requires logic. Power requires compliance. That is a stark, haunting distinction. What we've seen today in this deep dive is honestly staggering. By taking the official paperwork of a deeply flawed human judicial process and feeding it to 6 different large language models, the Chat Tools project essentially crowdsourced a digital legal consensus.
And those models didn't just offer a vague opinion. They exposed the exact surgical points where logic, domestic Chinese law, and international human rights were simultaneously abandoned.
They audited the math of the system.
And found it completely bankrupt.
Which leaves me with a final thought, something I really want you, the listener, to ponder on your own after we wrap up here. In this deep dive, we saw LLMs act as incredibly sharp, objective auditors of a state's legal judgment. They stripped away the political noise and just looked at the underlying algorithms of the justice system.
Right.
So as AI becomes ubiquitous, deeply embedded in our phones and daily lives, what happens to flawed justice systems worldwide when every single citizen has a perfectly logical, human rights-trained AI in their pocket?
A tool ready to instantly read a court ruling, spot the logical fallacies, parse the network theory, and expose government overreach in real time.
Exactly. Will this sheer, unaffordable computational logic force a new era of absolute judicial transparency worldwide? Or will systems built on unchecked power simply try to ban the AI completely? It's a collision between the cold logic of machines and the subjective power of institutions, and it's a collision happening right now. Thank you so much for joining us on this deep dive into the source material. Keep questioning the logic, keep holding the systems accountable, and as always, keep learning.